devo ringraziarlo perché ha messo insomma delle chiacchierate
Good morning. My name is Tunde, and some of you may be in my other courses. Some I'm sure I'm just seeing for the first time. We'll be talking about corporate finance in this model. It's essentially about the legal issues which arise in corporate finance transactions. What I'll do during the course of the model is to sort of take you through the various, not just the corporate finance issues, but also how to apply the law to the various transactions. The thing about the law is that we tend to sort of approach it in a silo way, in the sense that if you sort of pick up whatever law book you're looking at, so take the Companies Act, it really doesn't tell us anything about how to effect corporate finance transactions. So take a demerger, for instance, what the Americans call a spin-off. If you pick up the Companies Act, you're never going to find a section in the Companies Act dealing with a demerger, telling you how to do a demerger. But we do it, and the way we do it is to apply the law in different areas to effect that particular outcome. So that's why I referred to it in the seminar sheet as, in the introductory document, as really about corporate engineering. It's corporate engineering because we want to achieve a particular outcome, and we're looking for how to achieve this. So to go back to the example I gave, if a company, if the corporate finance advisors to a company were to say that the way the company has been sort of configured, it's a bit difficult for the capital market to value it. So take the case of a company which runs hotel businesses, right? So it has a portfolio of hotels. But also, it also makes weapons. How do you sort of put the two together, right? It's a bit disorientating. So the problem then is you'd always be sort of trading at a discount to your real value. So people who have been to business school will come up with a very easy solution to this and say, let's just spin off, one aspect of the business. That spin-off is a demerger. So if they come to meet you, how do you do it? There's no section in the law. But if you sort of understand the corporate finance issues, i.e. the legal issues now, you will be able to, in a really careful way, to look for relevant provisions which, on the face of it, does not seem relevant, but you'll be able to sort of deploy them in an integrated fashion to achieve that particular outcome. So an example would be this. We would say, okay, a demerger, if we're going to spin it off, ultimately we're trying to affect a separation between these two businesses and therefore between the personality of the company and the business, right? So you're taking one business away from the company. Now, so who does that business go to? Who has claims in that new entity? Now, presumably it's going to be the existing shareholders, right? So it's the existing shareholders, but you're just removing one particular business from a particular vehicle and saying to the shareholders, you will have an interest in this new vehicle. Now, the law basically talks about a return of capital. That would be considered to be a return of capital. And guess what? We have a provision in the Companies Act that talks about a return of capital. So that's where we'll turn to. And then we then say, okay, what are the sort of interests we need to protect here? The creditors, right? They're going to be worried that if this happens, this could prejudice creditor interests, right? So because we know this, we know what the law tries to guard against, i.e. Any transaction which would be prejudicial to creditors. So we sort of make sure that never happens. And then we then say, okay, how do we do a return of capital? So we look for the section on return of capital. And then how do we, in a sense, stream this to the shareholders? Look for provisions which deal with distributions. Right? Now these provisions are all scattered across the Companies Act. So when I talk about corporate engineering, it's really about bringing all of this together. Likewise, we could deal with a situation where, imagine a company from a foreign jurisdiction is facing a high tax rate, and they really want to, they want to be relocated somewhere else. So you talk about doing a corporate redomiciliation. Right? But again, if you pick up the Companies Act, you're not going to find any provision dealing with corporate redomiciliation. Right? But there are ways to go about it. And so that's essentially what we'll be doing. So I've just given, I could go on and give more examples. Take a debt equity swap. Right? So you have a company which has a huge debt burden, good prospects in the future, but a huge debt burden which obviously affects its cash flow. And therefore, if they don't do something, pretty urgently, the company could go under. And then your corporate finance advisors come and say, well, let's do a debt equity swap. Let's convince the creditors or some of the creditors to perhaps take a haircut or not even take a haircut, swap their claims from debt into equity. So how do you go about converting debt into equity? Now, the law, again, does not tell us anything about this. The law simply tells us about how you pay for shares. And one thing the law basically says is that if you're going to take shares, you have to pay for the shares. Right? You cannot take shares without paying for the shares. Neither can you take shares issued at a discount. Right? You can't take shares issued at a discount. And the problem now for the, I suppose, the bank is that perhaps at this point the shares are trading, because remember now the company's not doing too well, so the shares are trading at a discount to its share to its par value. So I'll talk about par value later on, but it's a nominal value you attach to the company shares. So the shares are trading at a discount to the par value, and you're now telling the bank to take those shares, and they're not going to be too happy. right? And, and there are ways. So the question is, how do you go about it? What sort of interest do you address? So these are some of the issues we'll be looking at. But before we get into the transactions, we need to sort of be very clear about the three sources of corporate finance. And that's what we really start with, right? So when we understand the sources of corporate finance and the law which applies to these sources of corporate finance, it becomes very easy, right, to then deal with the sort of serious corporate finance transactions. The case law is not very helpful when it comes to the corporate finance transactions because, as you would imagine, if things go well, then there should be no cases. Right? If everything goes well, if you do some restructuring and everything goes well, then there should be no cases. And indeed, if there is a case, maybe it's to sort of deal with one particular issue. And this is where the case law tends not to be very helpful, because if you're going to deal with one particular issue, then the lawyers are going to be very careful about what they plead. You don't plead too much, right? You make it very narrow, right? So that you don't sort of incur costs, or for tactical reasons, you don't sort of open things. So you try and imagine it this way. You pick up a law book, a law case, and you're reading about, maybe equity, and you're really seeing it through a narrow prism, the particular optics that worked for the litigants at that point. And to that extent, I find case law to be an accidental exposition of the law. All right, you have to read many, and kind of put them together. But more importantly, you've got to have a sense of the business case. What exactly are we dealing with? Having said that, we've got to work with case law, right? We've got to work with the statutory material, with case law. But more importantly, what I try to do in this seminar, in this course, is from the very beginning take you into market transactions, right? So we deal with market transactions. And in some cases, real-life transactions as they're going on in the city, we work with the transaction documents. So that way, you kind of understand what the drivers are. You understand what the drivers are. And I think that's about the best way to deal with this. Indeed, if you look at it's a point I make consistent. If you look at the textbooks in the area, the two leading textbooks, Gulliver and Ellis Farron, very solid academic textbooks, but there is a gap between what happens in practice and what you see in those textbooks. And when I give you the readings on virtually every topic, well, maybe not every, maybe about 90%, I suppose, you'll discover the big mismatch, right? So you're reading maybe about 15, 20 pages from me, and you're on a particular issue, and in a textbook, you're getting it dealt with in maybe one paragraph. Yet, that thing probably is one of the biggest things going on in the city. An example would be return of cash. That's a big corporate finance transaction, right, or type of transaction. Not just in the UK, but in the US. Right? So recently, as you probably know, one of the good things some people would say Donald Trump did in the States was to change the tax code, right? So there's, that's why it's very popular. At least in a setting, I don't want to get into the politics, but you know what I mean. So there's a lot of money. Whatever people say, whatever CNN says, employment is booming and all that, right? You can hate the guy, but jobs are booming, right? It's not magic. He reduced the tax burden, right? So companies which had tons of cash abroad are now injecting the cash back in the state, into the companies. So the big question then is, what do you do with all that cash that's coming back? What do you do with it? Especially if you're not able to invest that cash at a rate of return, right, better than your weighted average cost of your capital, right? So in that sort of situation, you need to give the cash to the shareholders. And indeed, a lot of activist shareholders are demanding this cash, right? So the question then is, what is the most efficient way from a corporate finance perspective of getting this cash to them? And that raises a number of issues. that we see being dealt with here and elsewhere on how to stream cash in such a way that it works well for the different shareholders, right? And now, in a typical textbook, they probably would say, well, we return cash through distributions, which we call dividends. But that's just a tiny aspect of the story, because in that kind of situation where there's so much money, it doesn't make sense to pay a dividend, because you'll be setting up a wrong dividend history, an unsustainable dividend history. You may decide to pay what they call a special dividend to send a signal to the market that this is a one-off, right? But for many reasons, people don't go down that route. They in some cases, they literally create new share types to return cash. So you create what we, in this jurisdiction, we call a B share, right? So you create a B share. So in this course, we'll be able to sort of design a share. And so why do we create a B share? We create a B share to enable us stream cash into the pockets of shareholders. But remember, the law says you have to pay for shares, right? And if we want to give you cash, the last thing we're going to do is say pay for shares. So if we are going to use a B share to stream cash into your pockets, it's because we're doing it in such a way that you do not need to pay for the share, right? Did you see? So in a sense, we could, for instance, capitalize reserves, right? So we take stuff, we take profit from your P&L account, move it to your share capital account, so we capitalize a particular reserve, give you bonus shares, right? And then, so because we give you bonus shares, you don't have to pay for it, right? That's why we call it bonus. So then when we give you these bonus shares, we then configure the rights which attach to those shares. And therefore we use that as a vehicle to achieve what we want to do. So what I've just essentially done is to talk about really just, I'm using these examples to illustrate just one key point at this point, right? It is that the law has to be applied in an integrated way in different contexts. That it's not very obvious what we're really seeking to do if you look at the law, but when you understand the transactions and you understand what the drivers of the law are, then it becomes easy to do this. So here I say that the course is about corporate engineering, and that's what I've been talking about. And then it also deals with some second-order problems, what I call the resolution of risk. So these are simply second-order problems which arise through certain decisions you've taken. So, for instance, the example I gave the other time about a demerger, you could say, well, we face a risk of devaluation by the stock market. How do we deal with this? Then you split, right? So that's why I call it corporate resolution of risk. And there are different types. So that's just one example. Hedging could be another, right? Hedging could be another. And you probably see this in litigation also. There was a case I dealt with where, so I was one of the arbitrators in this case, and it involved a company, one of the trading bodies of Shell. So basically they enter into a transaction to buy oil, what you call an offtake agreement. So the seller basically has an oil mining lease, oil well, whatever the seller produces, Shell is obliged to buy. So the only thing that would be different would be the price, right? Because if I'm obliged to sell you everything I have, the only thing that could change would be the price. And how do we know the price? We look at a particular screen and say, okay, maybe when the ship gets shipping instructions, we look at the Brent screen and determine the price. And anyway, there was force majeure. So because of the force majeure, the Shell was not able to take the oil for about 9 months. And then 9 months later, it came back after the first measure had dissipated to take the oil, and it then wants to pay the price that had been fixed 9 months before, which obviously was much lower than the price if you look at the screen today. So we have arguments about the construction of the contract. But one key point which came across, which I noticed, was that Shell was very good at hedging, right? So they enter into this contract and immediately hedge. And they're basically arguing for a particular construction on the basis that we should expect businesses to hedge. And the seller has no clue about this, right? The seller has no clue. And Shell is saying, surely this makes commercial logic that anybody who advises a company that goes into this kind of contract would want to hedge, right, as a way of managing risk. And the seller has no clue. And I'm asking myself as an arbitrator, I mean, first I think the argument is a bad argument anyway, because if I have to construe a contract, I don't construe a contract by reference to what you do after. I construe the contract as it is, not what one person does. But the argument of Shell is that in drafting this kind of contract, we should expect everybody, right? Everybody who advises a company in corporate finance to know how to manage risk. Therefore, when you agree on a clause, right, we have to read it in light of this understanding. We can argue about whether that is the case, but the point I seek to raise is that for Shell to put that argument forward, they truly believed that most people will hedge, and it will be careless people who don't hedge. The same way we expect most people will take out insurance, right? And you know, as opposed to you know, hoping that bad things don't happen to you, right? So I think that's the point I'm trying to sort of emphasize. So here, notice I said within the former context, we consider the latter, right? Within the former context. So within the context of corporate engineering, we resolve issues of risk, right? So so again, if we go back to the demerger point, right? It deals with a risk issue, but how do we do it? We do it in the context of the former, in the context of engineering, corporate engineering. And that's really about bringing the nuts and bolts in different aspects of the law to achieve the goal of the client, right? And then I did mention that a lot of second order, a lot of corporate risk issues really stem from second order transactions. Now, I then here say that ultimately we're really interested in the way companies raise and spend funds. That's what it's really about. It's about the legal aspects of the various ways by which companies raise and spend funds. And this obviously covers a very wide area, right? So you'll notice as we go along, it covers issues of company law, securities regulation, securities regulation, takeover law, contracts. It covers a lot of areas, and we try as much as possible to remain faithful to the core of it. So this is not a course in securities regulation. We're not really interested in these, in that aspect. I mean, the securities regulation bits are not too big anyway, but we try to grapple with a core issue of how you raise funds and how you spend it from the equity and debt aspects. We tend to focus, many people tend to focus on how you raise, not really how you spend, right? And another way of putting the same point is that we tend to focus more on equity and debt and not on net cash flow. And I think it's important to focus on how you spend, right? So because it raises a lot of issues. At what point does the law, in a sense, impinge upon the decision of management to spend in a particular way? So, for instance, if the transaction involves a massive payout, right? Say imagine a sale of a corporate asset, huge amount, 25% of value, then that's a class 1 transaction. The law basically impinges on the transaction at that point, and it says you need to get shareholder consent. But that's one. Another way the law impinges on how you spend net cash flow is, at what point should directors be under a legal obligation to return cash to their shareholders? Right? So if they have excess cash, what do you do with it? At what point should you even be under a legal obligation to return cash? That really would be the question. And also, if you want to spend cash, how do we measure it? How do we measure it? Let's keep it simple this way. Let's imagine the company has a treasury box, right? And all the company's cash is in there. Can you just spend it? Is there any way we control how you spend it? And the answer is yes. Well, what the law basically does is to say, well, if we have this box, people should pay money into that box, right? Paying, what do you call it, money, assets, whatever. You've got to pay something in. So for you to take a share, you need to be sure you've paid something in. And there's always a conflict between those who are to pay in, i.e. the shareholders, and the creditors. The shareholders want to pay in very little. And they'll do everything to pay in very little. They will lie that they've paid when they've not paid. They will engage in share watering, right? So you sort of transfer an asset of illusory value. You know where the term share watering comes from. It goes way back to a time when people used to sell livestock. So you sell a cow, and it's by the weight. So you make sure the cow is taking a lot of salt. So there's a lot of water, so the cow is heavy. So you kind of aquatize the livestock to get that. So the idea basically is that people transfer assets of illusory value to the company. Then the value given to the share becomes high, and that actually is in fraud of creditors. So we want to regulate that, right? But let's imagine everybody behaves well, and we have a cash box full of money. Then what can we do with this cash box? Obviously, we can run the business with it. At what point do we return money to the shareholders? Now, the law has to work out when to return money from this. And the way the law does it is to divide the cash box into two components: capital and profit. Right? Profit you can return. Capital has to remain. But the distinction between capital and profit is not very clear. And and this has haunted the judges for a long time, till I think later when we got the EU rules on capital structure, we see the rules basically coming up with a concept of distributable profits as a way of trying to measure it. So that idea of how you spend funds is really important. It's not just about the raising, it's also about the spending. And it comes up, and because we'll really understand it, right? Because we're really going to sort of dig down and really understand the law, you will then see how it arises in different areas. So if we do, let's say, a share buyback as a transaction, you'll notice that a share buyback will implicate this. Right? It will implicate it. So imagine the company is doing well. Company has a lot of money, but you want to increase the EPS of the company. You want to increase its earnings per share. So one way to do that is to eliminate too many shares, right? So you get rid of some of the shares in the market. And how are you going to eliminate some of those shares? By basically buying back those shares, right, from the shareholders. So how are you buying back those shares? You're using company funds. You're spending company money, right? So now the law had always said, no, this is never to be allowed. But then later on the law developed, some jurisdictions still say that, never to be allowed. But the law then moved on to say, well, so long as we can be sure of that division between capital and profit, if you want to do it from profit, then that's fine, so long as you don't touch capital. Right? So you can see how that's a spending issue. It's a spending issue. Likewise, the demerger, right, which does not look like a spending issue, technically becomes a spending issue because the moment you demerge, you separate one company. So, well, initially it's one company. So imagine a company running a hotel and also running an armaments factory. You then spin off the armaments factory as a separate company. Who owns the armament factory? The existing shareholders, right, of the former company. So you have to find a way to give them shares so that they own that. Now, technically, that's a return of capital. Technically, that's spending, right? And therefore, we need to be concerned about that. So I'm just trying to give you an idea of how this works. So notice here, I basically say that we focus on the three main sources of corporate finance, which are equity, debt, and net cash flow. Right? So, equity, debt, and net cash flow, and that's basically, what I've been talking about net cash flow, and to a certain extent, equity. Debt is a big aspect that we're going to be looking at because it's important for us, because it's a very flexible way of a very flexible tool of corporate finance. So if you use debt or the preference share, it's a very flexible way of doing it. Also, it raises issues that engage creditor interests, and therefore the objective of the law has to be to protect creditors. That's why every time you're to do a corporate finance transaction, no matter how way out it is, so imagine you don't know anything about this, so it's a blank slate and some guy from Wharton Business School has come up with this proposal. You've never seen anything like this before, no section in the law to deal with it. Always ask yourself, how does this affect creditors? That must be the first question. How does this affect creditors? If it does affect creditors, then be careful, because then that's a signal that you're going to get mandatory rules that would apply. So it then becomes necessary for you to identify those mandatory rules. Right? So, again, to use the example of a debt equity swap, or no, in fact, a better example would be a share buyback. It clearly affects creditors, right? Right? It clearly affects creditors because if you say that you're going to do a share buyback, the question is, essentially what you're doing is you're taking shareholders who are at the bottom of the pecking order, right? They have to be paid last. And you're basically paying them first, right? You're paying them first over and above creditors. That's essentially what you're doing. So because you're doing that, you're engaging creditor interest. And therefore we need to be clear that what we're doing should not prejudice creditors. So that's just one example. And, another way you could ask, there are many ways you could ask this question. Is there financial assistance for the purchase of shares? Right? So there may be no debt equity swap or share buyback, but maybe there's somewhere there's financial assistance for the purchase of shares. Again, that would prejudice creditors' interest. So what we're going to be doing as we go along is not just being mindful of every rule that affects shareholders, but we also need to be more mindful, in fact, of all the rules that apply to creditors. So that when we have great facility with these rules, right, when you know them, like in your sleep, right, you know them so well, then no matter how strange or odd the transaction is, you know what to do. That's really the point. You see, because most times those transactions don't go to court. right? Because if everything goes well, then nobody sues. It doesn't go to court. But yet people do it. People do them in the city. So that's why you then get a mismatch between the law in application, in practice, and the law you find in a textbook like Gower. So if you take Gower and company law, right, you'll be none the wiser. That's really, because it really won't sort of engage with those issues. So I just want to say one thing, and then hopefully you'll be able to ask questions. I just want to bring a few things together. So here I basically say that we start by providing an overview of financing options, right, within these broad categories we've been talking about. And then we talk about the juridical difference between these two, bearing in mind that they do converge, right? So people construct hybrids. So you construct a hybrid, how do we then classify it, right? How do we classify from a legal perspective, and how do we classify from the perspective of your financial statements? So if you look at international financial reporting standards, it takes a preference share and it sees it as debt, right? Because it's looking at the reality of it. It's debt. Whereas the legal classification would be it's a share, right? So how do we do this? So we talk about the construction of hybrids. And then we'll also then go on to, after talking about these two categories, then look at the other aspects beyond them. So here now we're now bringing them together, right? Because obviously we've looked at equity, we've looked at debt. We're now looking at how do they spend and how relevant does this become. So some of the points I mentioned earlier, like a Class 1 transaction, will be relevant. A corporate redomiciliation will be relevant. And so again, if we go back to the corporate redomiciliation point, if a UK company suddenly discovers that the tax rate in the UK is so high and it might be better to go elsewhere, how does the UK company redomicile itself elsewhere? And what sort of interest do you consider? What sort of documents do you prepare to make it legally effectual? Because the ultimate thing, really, at the end of the day, is to make the outcome legally effectual, right? Without any kind of collateral damage, right? So you want to be able to say, you know what, my client wants a redomiciliation. I've been able to do it. Shareholders are not complaining. Creditors are not complaining because it's legally effectual. And essentially that's that's the key thing we want to sort of consider. So here when I say that the starting point is the capital formation process, that is, what do I mean? When we start this course, we're going to start with equity, all right? Because we assume that with the capital formation process, we always start with equity. So you start a business, you take a share, and all that, and how do you go about this? I'm going to assume you don't know any company law. You may do. I'm going to assume you don't, and then we'll just go over the rules, but in a very sophisticated way, and sort of get to the nitty-gritty. And I'll tell you something about this bit, the capital formation process. It tends to give rise, simple cases give rise to really complicated issues. There was a case that I was involved in where a group of people formed a company and acquired an oil prospecting license. And in order to make the acquisition effective, they had to pay what they call a signature bonus. So usually the signature bonus would be somewhere in the region of about $20 million. And in the end, they didn't pay because, the government, basically, there was a change of government, and the contract itself was terminated. And so they basically said that the termination was wrongful, so they went to court. And so some shareholders kind of forgot about it. And they succeeded in court to show that the termination was wrongful. And now, having succeeded, those shareholders came out, right? Because now they know there's an oil company that has massive reserves, right? So their grandchildren won't be poor, right? So everybody's like very interested in this. And the question then boils down to whether those guys who sort of stayed by the side had paid for their shares, right? And there was no money moving between them and the company, but yet they had done things for the company. So they had paid for services for the company. So maybe you pay an engineer to do stuff for the company. So how do you connect this? How do you demonstrate that they've paid for their shares in that kind of situation? You get the point I'm making? And because the guys who are now in control of the company are saying, well, if you haven't paid for your shares, we, by the way, have exercised forfeiture rights, right? We sent out notices to you, basically saying, you know, pay, we're doing a call, pay money, and if you don't pay money, we will exercise forfeiture rights. And that's what we've done. And therefore, you have no interest in the company. And the other folks are saying, well, we have paid, but how do you connect what they have done with the company? Do you get the point I'm making? How do you do this? And then it becomes all complicated because you get into the area of assignments and all, you know, all manner of things to show that they had paid money to the, well, they hadn't paid money to the company, so you just have to find ways around that, right? So that's one example. That's one example. So what if one of them said, well, I wrote the business plan for the company. What if one of them said, I wrote the business plan of the company? And they said, okay, can you show us? Well, it was on 1/3 of a page of an A4 sheet. And I believe that that business plan is worth, so assuming he had to pay £10,000 as a share, I believe that that business plan I wrote is worth £10,000. And the company took benefit of it. What would you say? What, you know, so he's saying, I wrote a business plan on 1/3 of a page of A4, which, by the way, we don't know where it is now, but it's there. The guy took it. And I believe it's worth £10,000. And that's payment for shares. How would you sort of process this? Just thinking about it. And then let me sort of complicate it slightly further. So maybe two of them. One says that. Then the second one says, well, I paid by, you know, telling you that I will pay in the future. Right? So two people come up with two different ways of paying. One says, I wrote a business plan. And the other one says, I did promise to pay in the future. So I want you to treat that promise as present payment. Right? Now, so those are the kind of issues that could come up, right? And a lot really, you know, hinges on this. So, but how do we work this out? How do we work this out? You know, let's take the last one. I promise to pay in the future. Remember, to work out whether somebody has paid or not paid, before we even get into the law, we need to understand whose interests matter. The aim of the law in regard to the capital formation process, which is what I'm dealing with, the aim of the law at this stage is to reconcile the conflicting interests of two groups of people who have adverse interests. Creditors want shareholders to pay into the corporate treasury, Shareholders don't want to. Creditors want a well-funded debtor. Shareholders do not want. But when it comes to taking things out of the corporate treasury, shareholders want to take things out. Creditors say, no, we don't want you to take things out until we get paid. So that way we can sleep peacefully at night. Right? Shareholders are essentially saying that we shareholders and you creditors, we're all in the same business together. We just want a buck. We're in business to make money. Right? You get a claim, I get a claim. Your claim is a chosen action, my claim is a chosen action. Right? Are they really that different? You have limited liability. Yeah, the creditor has limited liability. He only loses how much he lends to the company. The shareholder has limited liability. So, in a sense, we're doing the same thing. And if we're doing the same thing, why should I stand by chronologically till all creditors have been paid? Why can't I get money now? And that would be the kind of argument of shareholders. So, what the law tries to do is to come up with a set of rules to achieve at least a partial reconciliation of these conflicting interests by saying that, well, we're going to divide it into two phases, the paying in phase and the taking out phase. Here we're concerned with the paying phase, right? So at the paying in phase, we want to be sure that you pay what you promised to pay. So we're not going to regulate you. We're not going to say to you, you must pay X amount. In other words, there's going to be no minimum capital pay-in rules. Right? We're never going to have a rule of capital adequacy to say, well, if a company doesn't have, it's not a bank, it's not an insurance company, just a normal company, if it doesn't have a certain amount of capital, you should wind it off. No, there's no such rule, right? So if you promise to pay £1, then pay in the £1. If you promise to pay £10,000, then pay in the £10,000, right? So let's go back to the guy who says, I undertake to pay in future. Well, the fact that he undertakes to pay means that the fund he promises to pay remains there intact for creditors. That cannot be a bad thing. Therefore, we should treat it as payment. In fact, I would prefer, as a creditor, I would prefer a situation where the guy says, I promise to pay. Because guess what? If the company is to be wound up tomorrow, at least I know I can hold somebody and say, you promised to pay £10,000. Have you paid it? No, you've not paid it. So please pay to the liquidator. But assuming he had paid it earlier and the company had frittered it away, the liquidator will have nothing to hold on to. The point I'm making is this. When I gave that example, when I said, I promise to pay later, you probably thought, wow, this is bad. Actually, technically, it is correct. And I've been able to arrive at this without even looking at the law. If you look at the law, yes, that's the answer. But we're not in the business of memorizing the law. We need to understand why the law does that, right? So if we kind of reason that way, right? Because remember now, there are two contexts where these things can arise. They can arise in litigation or from a transactional standpoint, right? In the example I gave, we're talking about it from a litigation perspective, right? A person is saying, I paid. So I suppose the answer would then be, if that is the argument, we would say, clearly, he did pay, and therefore he's a shareholder. Right? In regards to that. What about the first one? The guy who says, that business plan I wrote is worth £10,000. Now, do you think as a judge you are equipped to second guess the value of what he wrote? I mean, you think so? What do you think? So, you know, because it's kind of, courts don't like to get into this business of second guessing, you know, the value of these things. So generally speaking, the courts would say, well, you know, if he said he paid 10,000, so if he said that this document was worth £10,000, then we're going to trust the business judgment of the managers. We're not going to second guess it, unless of course it's so illusory, it's so colorable that it's such, it's been used as an instrument for fraud. But we're not going to second guess normally. And this principle has been part of company law right from the time of Solomon, a famous case in company law, decided in 1897. In 1897, when that case was decided, the House of Lords did say that the value that Mr. Solomon put on his business in Whitechapel represented the sanguine expectations of a fund owner. That's how they described it. It wasn't realistic, but they didn't second guess it. So that one-page paper might actually be relevant, might actually be worth that, well, not worth, but it could be regarded as appropriate payment for shares. So, and just to sum up on this point, these issues that we talk about can arise in a litigation context or in a transaction context, right? So just be mindful of that. Obviously, if you're doing a transaction, right? If you're doing a transaction, you want to reach a particular outcome, then you're going to say, okay, in order to reach this outcome, right? So they've asked me to do some kind of engineering. I don't really understand it, but they've broken it down. And then I say, because I've done corporate finance, I think I should be able to work it out. So the first question is, are they raising capital? Right? That would be the first question. Remember, capital formation. Are they raising capital? If the answer is yes, are the shareholders paying for the capital lawfully? The answer is no, then your transaction becomes void. You got problems. Right? If the answer is yes, they're raising capital correctly, and now with those two examples I've just given, you can see how we came up with answers to two quirky issues, right? So they're raising capital correctly. Then the second question would then be, or is it second or third question would then be, what about creditors, right? Are creditors' interests prejudiced? And if the answer is no, are there any security interests? Are they creating security? And if they're creating security, is the creation valid, or can the court recharacterize it? Because you could say, well, I'm creating a fixed charge, right? A fixed security interest over, let's say, receivables, right? So account receivables, money owed to the company. You're basically saying, money owed to the company, which will come to the company in future. I am creating a fixed security over it. Well, but are you sure that you really created a fixed security if the company has the ability to play around with the assets without any kind of restriction? Think about it. If you have a house and you borrow money and there's a fixed security, i.e. a mortgage, you can't sell your house to somebody without the consent of the bank. You can't rent your house out without the consent of the bank, right? Otherwise you'll be in breach. In other words, there are restrictions of what you can do, right? There are restrictions on your autonomy because it's a fixed security. So if we take the same idea, so instead of seeing a house, right, we just become a bit imaginative and imagine claims, right? So instead of a house, we imagine claims, but it's cash, right, nevertheless. And I hope you're with me on this, right? So we imagine these claims, and then we purports to create a fixed security. Just the same way we'll do to the house we see. But we do not behave as if it's a fixed security. Then a court is likely to say that actually we will recharacterize what you've done. You've not created a fixed security, you've created a floating security. And if that's the case, it affects everything. Right? So those are the sort of questions you want to ask. So you see how we've brought in the debt into it, right? At the point of structuring a transaction, right? So essentially, what I basically say in regard to creditors is that we've got to be careful about creditors because limited liability has a price. You know, when we get limited liability, right, there is a price. Because, you know, limited liability gives you the right not to pay all your debts, isn't it? You're only limited to how much you promise to pay. So if you're going to be protected that way, then there has to be a price. And that price you pay for limited liability is what? It's a set of restrictions, a set of rules that we have to master. Right? So when you see me concerned about creditors, looking for how creditors are affected, it is because I'm aware of the price we pay for limited liability. And you can check this out easily by changing the scenario. So imagine the company involved is set up as an unlimited company. Right? Then guess what? The creditor's interest won't be that important. You know, Mobil, in a particular, you know, Mobil, the oil company. You know, I remember reading. I was reading some documents, and you know, in a meeting, and so Mobil was in a particular jurisdiction, and it was using an unlimited company structure, and some of the lawyers could not understand it. Why is Mobil using an unlimited company structure? But immediately I knew what was going on. Mobil wants to move money around and not worry about creditors. Once it's limited, then you have to contend with creditors. You have to contend with all these rules we've been talking about that affect creditors. Right? So essentially, that's why we need to be mindful of these mandatory rules. So let me stop here for the minute and then you know, see what kind of questions you have before I continue. Yeah.
At the beginning, you talked about financial resolution of risks. Can you give us some examples of what are these risks?
Yeah. So, obviously, hedging. Hedging would be the resolution of, depending on the kind of risk you're dealing with, it could be currency risk, market price risk. So in the example I gave, the seller, or rather the buyer, who was obligated to buy the oil through the offtake agreement, had two risks. One would be the risk of force majeure, right? Assuming something happens and you declare force majeure, then you can't get the oil. And the other one would be that if, as a result of the force majeure, and it's called off, you then get the oil, at what price would it be, right? Because the price could change. So now, and that basically means that you're talking about currency risk, right? Because prices change, you're dealing with a particular currency, maybe the currency, the relevant currency suffers a diminution in value. You just want to hedge that. So that could be one type. Another could be you're in a type of business and you believe that that particular business is exposed to massive regulatory risks. So we all know, for instance, that if you are in certain businesses, let's say in the construction area, and the greatest area for corruption is the construction business, right? So, and that's why the mafia, they love it so much in places like Italy. So many opportunities to do things. Now, if you have exposure to a jurisdiction like the United States, right, and you also have exposure to, let's say, a developing country where corruption is regarded as pretty intense, it means that you could be hit with massive penalties in the States. We're talking about penalties that go up to $1 billion. So we're talking about an investigation by the DOJ, the Department of Justice, the US SEC, hitting you, right? With, think about Siemens, the German company, right? Companies like that, which had that kind of exposure. Think about companies like Baker Hughes, oil servicing company, which basically came under scrutiny in America. Now, so in that kind of situation, there are many ways you want to sort of try to manage this kind of risk. So you could manage it from a corporate governance perspective, right? So how do you manage it from a corporate governance perspective? You make sure that you have proper procedures in place, proper risk management procedures, chief risk officer, reporting lines to the board, the audit committee looking into it, probably a risk management committee looking into it, those kind of things. And making sure you comply with public procurement rules, right? And things like that. Or you may just decide, this is too risky. Why don't we just spin off this company, right? So in that case, it then becomes not a corporate governance approach to risk, it becomes a corporate finance approach to risk. You want to resolve this particular risk. So if they walk to me and say, how do we resolve this risk? From a corporate finance perspective, I would say, well, spin off the company. Spin off the company. That way it does not affect the other company. That will remain. Do you get it? Yeah. So in that case, we will then say, okay, how do we spin off the company? So we could use, let's say, a scheme of arrangement, right? So under Part 26 of the Companies Act, there's a provision called scheme of arrangement. Now, guess what? We always use a scheme of arrangement when we do, when we're trying to sort of, enter into some kind of resolution with creditors, right? So you owe creditors and you're doing some corporate insolvency procedure. So we use a scheme of arrangement. It becomes an arrangement with creditors. We also use a scheme of arrangement when we're doing a takeover, right? So a typical takeover transaction is implemented through a Part 26 scheme of arrangement, because then it becomes an arrangement between the company and its shareholders. Again, we can use a scheme of arrangement to effect a demerger. So one procedure doing so many things. Do you get it? One procedure. If you look at Part 26, and I think that's, I'm happy you raised this question because it really touches the key points I'm trying to address. So if you pick up the Companies Act and you see Part 26, it doesn't say anything about a demerger. It doesn't say anything about a takeover or a merger, right? It says nothing. All it says is that a company can enter into an arrangement with its members if you get the relevant thresholds, right? 75%, and you get court approval. That's all it says. Okay, so if you pick up the Companies Act, you can read it 1,000 times, but that's all you'll know. You'll know that there's a provision called scheme of arrangement. Now, if you pick up a textbook, it would also say, well, in Part 26 we have a scheme of arrangement. And it will describe all the sections and footnote them, right? The usual way. And then if there's one case or the other, it will refer to the case, right? And you think you know it. Now, I say let's deal with it slightly differently. Let us not start with the law. Let us ask, what does the client want? In this case, to answer your question, the client has identified a risk which it cannot manage, or it is unwilling to manage from a corporate governance perspective because it's too big, right? So they feel this is toxic. They need to get rid of it. And how do you get rid of it? They come to meet us. We say, well, we have a solution. It's a solution from corporate finance that will enable us get rid of it completely. And what is it? We will spin it off from the company. Well, check the Companies Act. There's no provision on spin-offs. But because we now know, what is involved, we will use the scheme of arrangement to enter into an arrangement, right, between the shareholders and the company, whereby this is then done, right, making sure that creditors' interests are protected. Simple. And that's one way you manage it. Does that answer your question?
Yes.
Okay. Any other questions? Any other questions? Yeah. And also, maybe I could even add another one. A company is about to go into insolvent liquidation. And you've looked at the various ways to solve the financial problems, and you really can't, right? So you're thinking about an insolvency regime, but it's just not going to work. So the only thing you can really think about is a debt equity swap, right? So there's a risk. So how do we resolve the risk? The risk of the company going into insolvent liquidation. So if the company continues to trade for the next 8 months, the company will go into insolvent liquidation. Even though if the company survives 2 years, China is going to open up for the goods of that company, and the company will do well. So what you really need is to save that company, right? So you then say, I have a corporate finance solution to manage this risk. And what is the corporate finance solution? It is to take the debt and convert it into equity. So the bank has debt, right? The bank is owed. And what you want at the end of the day is for the debt to disappear and for the bank to have shares, right? But how do you make this happen? How do you make this happen? Because the law says everybody should pay for their shares. Clearly, the bank is not going to pay for any shares. If the bank has a note, for every note the bank has, right, it's owed £10,000. What the bank wants, at the very least, if it's going to do this deal, is a note saying you have shares worth £10,000. The bank is not going to give you 1 penny to give up the debt, right, to take shares. Instead, the bank is saying, I really don't need this deal, right? But if I'm going to do it, then give me something in exchange. But the very thing you're going to give the bank is a share, which the law says you've got to pay for. So the question then is, how do you solve this problem? Well, that's a corporate finance problem. What do you say, by the way? What would you... What would come to your mind? Yeah.
You compensate the value of what the bank would have to pay for the shares against what you owe.
How do you...
I mean, it would be, if both are debtors and creditors, the debtor would be cancelled off.
Yeah. So okay, yes, the bank clearly is owed, right? So the bank has a note. Let's simplify this. The bank has a note where it says, you promise, the company promises to pay the bank £10,000. That's the note, evidencing the debt claim. But clearly there's no money. The company has no money to pay the bank. But the bank, that note is an asset to the bank, right? And the bank can sell the note, obviously at a discounted price, right? So you then trying to convince the bank to make this note disappear, make the debt disappear. And you're saying to the bank, in place of this disappeared debt, I will give you a share. Now, obviously, the bank does not need to accept this deal, right? Because a share may be worthless. At least a debt is something, right? This debt may be worthless if the company goes into insolvent liquidation. So I guess you could convince the bank, you could say to the bank, you know what? If you don't accept this, we will collapse. And if we collapse, your debt is worthless. But if you accept this and we survive, and China opens and all that, we will trade, and guess what? The share will be of value. And if you like debt so much, because you're a bank, and that's the only way you can think, we can even configure the debt in such a way that we give you preference shares, like redeemable preference shares. So we'll attach a coupon to it, right? Which behaves like interest, right? And it will be cumulative preference shares. So yes, this year we can't pay anything because we're broke. But guess what? In 2 years' time, we'll be able to pay you your cumulative dividends, right? So we're saying to the bank, what do you have to lose? Nothing. You get a share, which is like a debt with a coupon rate that approximates your old one. What do you have to lose? So the bank says, okay, yeah, I'll take that. That makes sense to me. And so we then say, okay, we're going to make the debt disappear and then give him a share. But the question then is, the law says everybody has to pay for the share. So to come to, because I want you to relate it to this, that is the question now. How does the bank deal with that requirement? Because we know the bank is not going to pay. I mean, if you're a bank, why will you pay when you're giving up something? So what do we do? Sorry? Yeah, so we waive the debt. Yeah, we've already agreed we'll do that. Yeah, but that's...
That can be seen as paying.
Aha, okay. So in law, the extinguishment, the release, in fact, the term would be the release of liability for a liquidated claim is regarded as payment in cash. You're right. So that would be the way. So that way, if you know that, then you're able to solve this particular problem, right? So this is just one thing which will come up on the way, right? Just one little practical problem which could sink the entire thing, right? Because if you don't find a way to demonstrate that the bank has paid for the shares, then the entire thing you're doing to resolve risk will collapse. Just the same way I told you about so obviously in this example we're talking about, this is a typical transactional problem. But in a litigation problem, remember I gave you the example of the shareholders who had got who were shareholders of a company that had got an oil prospecting license, and some of them had not paid for their shares, right? Because there was no evidence of any money coming from them to the company, right? And so in that kind of situation, you have to find ways such as what she's just mentioned, if you can, right? Okay. So when it comes to a lot of corporate finance transactions, you'll notice that one of the things you'd have to do would be to design shares. You design shares for so many reasons. When people think about a share, a typical practitioner just thinks about a share, right? But if you do corporate finance, I think we should see the share as an instrument we create and we can mold and design to achieve what we want it to achieve. All right, you get it? So I'll give 2 examples, one from America and one from here. So so when the takeover boom was sort of like really expanded, and target management were being assaulted by corporate raiders, and the target management sort of tried to appeal to the states in America, right, to pass what they call anti-takeover statutes. So all the states were busy passing these laws. And then the Supreme Court, in a case called Edgar and Mites, basically struck them down and said, these laws, these anti-takeover laws passed by the states are unconstitutional, right, because they impede interstate commerce, right? So what then happened? So this lawyer, Martin Lipton, he goes back and says, let's do something. He designs a share. He designs a share that has the effect of becoming poison in the pocket of a bidder. And how does he do this? He basically does it in a way, he says, well, we're going to amend the articles of a company and pay people a dividend, right? So you pay people a dividend, and that dividend will include share rights. And those share rights would give you, a shareholder, a right to increase your holdings if another person acquires 30% or more, right? So when the bidder acquires 30% or more, right, it triggers a right in your pocket that has the effect of diluting him out of existence, right? Or other things that he would find unpalatable. The point basically is that the poison pill was invented. And the poison pill was invented because of the mastery of the share. And I have always said that one of the advantages of a common law, and I know how this sounds, but I hope you would excuse me, of a common law jurisdiction, is that we're very flexible when it comes to shares, right? And, some systems are not, right? And I think this affects your cost of capital. It affects how malleable you are in the market. You follow? So I'll give you an example. There was once I had to go give a paper at the World Bank conference. And so there was this jurisdiction which, there's a law, and it's still there. The law basically says every share shall have one vote. Right? Every share shall have one vote. And everybody thinks this is normal. Right? But this, for me, is absurd. How can every share have one vote? There is no democracy here. There's no, when you talk about business, it's a plutocracy, right? It's money that gives you rights, right? So it kind of reminds me of a company statute that must have been designed by NGO activists, right? So everybody has one vote. Therefore, every share should have one vote. Right? Now, from a corporate finance perspective, we should approach it differently. We should say that we leave the people to decide on how to allocate rights, not the state. Right? So we know that a share will have capital rights, income rights, and control rights. Right? But it does not need to have all three. Because I could decide that, you know what, I want high income rights that are guaranteed, and therefore I don't need control. I don't need to vote if you're going to be giving me 20% every year. Why do I need to vote? So why should the state intervene and usurp our right to enter into contracts and replace it? And that's exactly what they did. Right? And what has then happened, because I picked this up and I was saying, this doesn't make sense. And I was talking to a practitioner there, and he was saying that, because, whenever you get anything that's absurd, you'll always get private ordering responding to it. So you understand what I mean? So you get some absurd rule. So, okay, let me not be pejorative. So you get a restrictive rule. Human beings are flexible. So what they would do is to order their private affairs around it. So in this case, what tended to happen is that the shareholders will execute shareholder agreements, right? Basically saying that some shareholders should not have the right to vote their shares, or some people should have supermajority rights. But the problem is that you're not sure whether it's effective. You're not sure whether a court would say, well, this provision in your shareholders agreement runs counter to the company law. Now, so I come back to the point about configuration of the right of participation. That one key thing about our corporate finance system is that we have complete flexibility when designing a share. Complete flexibility. You can design a share with only control. No capital, no income, just control. You can design a share whichever way you see fit. And this then means that when it comes to private equity transactions, we are really very good at using the share effectively, right? So you get people who can calibrate the share rights precisely as they want. Now, other systems are not able to do this as effectively, and I think it's important that we look at this. So one of the things we're going to be looking at is how you design share rights. And here I say consider the configuration of the right of participation. And I use the example of a private equity transaction in the context of a buyout. And we're going to discuss this and see how you configure. But actually, from next class, we will be looking at this. So I said, as we shall see in Seminar 2, you have a right to income, capital, and winding up. And so from Seminar 2, we'll be dealing with configuration, right? And the learning we do in Seminar 2 can then be used when we get to, let's say, Seminar 11, right? If you're doing a private equity transaction. This is the point I'm making when I talk about applying it in an integrated way. So here, we in Seminar 2, we basically learn the various aspects of share rights and how you configure them. And then after that, we then say the legal rules applied or examined in Seminar 2 and 3 are then applied commercially, right? When we deal with private equity transactions. This is the point. So, so if you know, I keep on emphasizing the fact that we're going to be applying these things in an integrated way. So when I look at rules in Seminar 2 or 3, and I'm saying, okay, there's this rule on shares and this, in practice, that's not how it comes out. In practice, it comes out in the context of a problem, right? In the context of a transaction. And that's what we're going to be doing. But obviously, I'm not going to wait till we get to 11, because what we'll do, as we do this, I'll be flagging up these things and using transaction documents. So even in Seminar 2, we're going to have a transaction document to illustrate some of the points, right? So that they will be clear. And then I then say here that another example is the law on capital reduction, which we do in Seminar 6, but then we look at the transactional use in Seminar 7, which deals with returns. And then debt financing, again, the same thing. So we're going to look at the different forms of debt finance. So different forms of debt finance, layers of debt, so your senior debt, mezzanine finance, and security interest. And remember the point I made earlier that that debt finance is important from two perspectives. One, corporate governance, and then the second one, because of security issues, which I talked about briefly when I said recapitalization. Remember the example of the fixed charge and all that. And then we will conclude by examining three major kinds of financial transactions. So we're going to look at a corporate restructuring involving a debt equity swap. We're going to do a spin-off. And we're going to look at the equity and debt aspects of a private equity transaction. So here we're dealing with, imagine, so it's going to be in the form of a story, I suppose. So the first part of the story is, a company that has financial problems. So the company has financial problems and all that. It's about to collapse. And then you do a debt equity swap to save it. Right? So having saved the company, the managers of the company become greedy, right? Which is not a bad thing, because that's just normal, right? So they're greedy. They want to buy the company from the shareholders. So they go to meet funders who are prepared to provide equity and debt in the context of a private equity transaction, and then they do it. And they do it in such a way that the shareholders are happy with it, right? So the shareholders are protected, the shareholders get good value. So the question then is, how do you then reconcile the interests of the providers of debt finance, right? And the providers of, in fact, the providers of debt finance could be in different categories. So the providers of senior debt would have interests that are different from the providers of mezzanine debt, right? So you have that. Then you have the providers of equity, right? The providers of equity. So the directors themselves, right, who are greedy, will provide some equity, but we know they can't provide all, right, because they're poor guys, right? They don't have too much money. They're putting out their houses on the market and all that to raise money, but so there'll be other providers of equity. So the question then is, how do you bring all of this to gel within this transaction in such a way that A, it is fair to the shareholders who you're buying out, because you have to buy them out so that they give up their shares, and the interests of the different classes of debt providers are taken care of, as well as the relationship between the providers of equity and debt. So this is why we say, in this context, we are able to apply things in an integrated way. So I said these provide a fascinating context in which to apply the law in an integrated fashion and to examine the relevant issues. Right. So regulatory terrain, Companies Act, and all those statutes, we'll go along as we see them. But I just want to sort of lay out the topics. So today is obviously the introductory seminar. Future seminars won't be like this. For a start, you will have a break. Right? So please, I just thought, let me just ramble on. So you have a break. And there'll be hopefully much more dialogue, right? And all that. So in short, it will get only better. Right? This will be the worst, you'll see, right? It will get better. So next time we meet, we're going to talk about shares, the unit, which is an item of property in my pocket, not owned by the company. Then share capital, which is property of the company, right? And the need for its measurement. Why do we have to measure it? Because so we're not measuring the shares, we're measuring share capital, right? So all of us have shares, but how did we get shares? Because we gave capital, right? The law says you've got to give capital. So when we gave capital, we got shares. Where did the capital go into? It went into that box, right? That box. Now, but why do we have to measure it if it's in that box? Because when we trade, the box increases. It changes, right? So if we're trading and we open the box 1 year later and it's now larger than what we put in, it means we've generated profit. So we need to be able to measure it. Why? Because many corporate finance transactions you will do, unless it's an unlimited company, virtually every corporate finance transaction you do can only fly if you have distributable profits. Otherwise, creditors will be affected. Everything we've been talking about, if you don't have enough distributable profits, it's not going to work. So we need to be able to measure this. And how do we measure it? So it's again, we're going to go into this in great depth, right? By far more than your typical textbook, right? But hopefully, and when we finish, we'll be very confident about measuring it, right? And this will be useful in so many areas, right? In so many areas, and then we would then be talking in Seminar 3 about how to raise capital, and then share capital alteration, and then Seminar 4, legal protection of share capital, which is important, again, because every aspect of corporate finance you can only do and advise competently if you understand the rules on legal protection. If you don't understand the rules, you'll bankrupt your client. And then the law and financial assistance for the purchase of shares, and then capital reduction, and then returning cash to shareholders. And then debt finance, overview and fundamental concepts, taking security. And then when we get to 10, we'll be looking at corporate restructuring. So here we're looking at debt equity swaps, debt and the equity and debt aspects of private equity transactions, and we're kind of continuing with that, and then revision. Right? There are going to be tutorials with Mr. Nigel Banerjee, and they start next week. So the week starting 14th January. They're going to be held on Thursdays and Fridays at 1 p.m. Right? Thursdays and Fridays at 1 p.m. You may be interested in textbooks. And there are these two textbooks, Farron and Gulliver. Now, you can easily get by without any of these textbooks, easily. In fact, you would notice that on many topics, the material that I create for each class far exceeds what you will get in a textbook. So that's why I say, but if you want to sort of have some, alternative voice to give you an overview, then fine. I think Farron's textbook is stronger on the equity side, whereas Gulliver and Payne are stronger on the debt side. Right? Okay. For those who are not used to English case law, you might just want to have a case book to dip in. I wonder whether you should buy a case book because, how many cases are we really looking at to justify the expense? I'm not so sure. But obviously, at the very beginning, we're going to have quite a lot of cases, right? So I leave that to you to decide whether to get a case book. The advantage of a case book is that it gives you a summary, and, as opposed to you reading many pages of turgid legal prose, right? So, and capital cases, I've got to warn you, they're not exactly exciting, right? They're not exciting. So please don't be put off. It's going to be, you'll get, like everything, you persist, you end up liking it, right? But some of the old cases, they tended to have very complex capital structures, and, so they're not very clear. But I don't think that's going to be a problem. Certainly, it has never been a problem in all the classes I've taught. The students never complain about this, and the general feedback has always been good because of the way we've dealt with it. Remember, the idea is to make it practical, so to use theory to eliminate the practice, and the practice is not far away because it's there, you're seeing it. We're not waiting for the cases which are accidental, and neither are we relying on the textbooks, right? Okay. And then there's the statute book. So the statute book, obviously you need a statute book, right? Because it contains everything, right? There are many statute books. So you have Blackstone's, Butterworth's. I normally use, Butterworth's, but it's pretty expensive. So we're talking about over £100. So whereas if you use Blackstone's, probably, I don't know, maybe £20, £24 thereabouts. So there's a big variance. So you see what works for you. So does anybody have any questions? Yeah.
Two questions. You presented the case of debt equity swap between the bank and the alien company. So the issue of shares, a new class of shares, for example, would dilute the overall value of the outstanding shares.
Yes, that's right.
So in that case, a shareholder, normal shareholder, another shareholder, can sue the company under Section 9 and 4 for unfair prejudice.
Yeah. So, I get your point. But he would have to be quite foolish to do this because we're talking about an existential problem, right? So the question is, does the company survive or not? And so the guy is saying, I want to protect my rights in the company, but sorry, if the company collapses, then you have nothing. Did you get the point? So yeah, because by the time you get to the point where you're doing a debt equity swap, right? So, you clearly have an existential problem. So, the answer is very simple, and it's one of the things that will be on our checklist. Before you do it, you need to get the shareholders to waive their preemption rights, right? So shareholders have preemption rights. If you look at Section 551, you see preemption rights, 555 and all that. So one of the things on our checklist to do this, right, would be, A, do the directors have authority to issue new shares? B, do the shareholders have preemption rights? If they do, so there'll be standard preemption rights, then get them to waive it. So your point would come in at the advocacy level, i.e. if I'm writing to the shareholders, I'll say, your company is going to collapse. And yes, you have preemption rights, but you have preemption rights in a dead company, right? So the only way to save the company is to do this.
Yeah. But if everything goes smoothly,
If everything goes smoothly, then what?
Anyway, the value of the outstanding shares is less.
Less valuable than if the company had collapsed?
Yeah, no. I mean, yeah.
Do you get the point? Yeah. So the company is going to collapse anyway, right? So we're trying to save the company, right? We're trying to save the company, and we're saying to you, please just waive it, right? Now, I don't think the bank actually wants to be a shareholder permanently. That's why the bank is going for redeemable preference shares. The bank is not going for ordinary shares. The bank is saying, I want exit. The bank doesn't want to remain in the company. The bank says, I want exit. And so the bank is even negotiating with you. Can we have exit at, let's say, 5 years, 3 or 5 years? Right? So guess what? If you're so concerned about you come back to normal, right? Because the bank will be out anyway, because you would have designed the shares that way at Seminar 2. Did you get it? So at Seminar 2, when we're designing the shares, you design it so that the bank would be able, if it has redeemable preference shares, to say, you know what, I want to be able to leave the company.
Another question.
Yeah.
You talked about spin-off. Can you use spin-off to impede hostile takeover? Like, I have in a company.
I get your point.
Like a technological.
I get your point. Yeah, I get your point. Yeah. I understand.
Growth rate.
I understand what you mean. So the answer is this. You will not be able to lawfully, right, because it will infringe Rule 21 of the Takeover Code. It will be frustrating action, unless, of course, the shareholders consent to it, right? In any event, for you to do a spin-off, you need to get the consent of the shareholders, right? So, so if the shareholders like it, right, then fine. And presume the shareholders will like it, because ultimately the shareholders have to compare two sets of values. How much are we going to make from the spin-off with how much the bidder is offering? Right? So it's a very good question, actually. It's a legitimate response to a bid, because if a bidder is offering you, say, a 30% premium, you could say to shareholders, you know what, we can generate by far more than that, right, because we think the market is undervalued, but we need your consent to do this spin-off.
Do you need a special resolution, or?
Yeah, so because obviously the basic rule in company law is when you have these constitutional issues, you need special resolutions, right? Yeah. Okay. Any other questions? None. Okay. So hopefully we'll see next week, and I look forward to seeing those who remain. Yeah. Okay. Cheers.
So it's not related to corporate.
No, I know.
Tied to the time period or to the offer period.
So, good question. Sorry.
Because obviously you say the thing would not apply in case of pre-offer event. But in the case we have an announcement that triggers an offer period, from that point onwards, would the thing apply? Or the thing is really tied to the timetable, so when the offer goes up?
No, I get so remember now, what basically says, as clarified by the language during the currency of the brain. That's the language. So if I could argue this either way, right? So the two things, and I can even stretch it a bit, right? So I could say, look, the court says during the currency of the brain, when is there a bill forward? It is when the 60-day time will be start, right? So when you triggered your 2.7, send the bid out, then that's the currency of the bid, right? So the currency of the bid is different from the offer. So I'm arguing the currency of the bid is different from the offer period, because the offer period is really not about an offer, simply to get the market aware, right? Of the possibility. It's just instrumental, right? Okay. So that would be the idea. Now I can imagine somebody, if I was paid enough money to argue the opposite, I could say, well, when the court said during the currency of the day, they don't just mean the 60-day period. They mean certainly when the market is aware that there is likely to be an offer. Right? I could do that. So I could argue it differently. Right? So it really depends on your interpretative style. If a judge takes the words of data from like a statute, then it would be the 60-day. I kind of feel that you can easily convince the court that it's because even the word offer period, how many judges are going to say, wow, what is the offer period? And it's all tied. Now you know Rule 8. Not many judges know that. And by the way, you can even extend it a bit further to say, well, what about when, well, maybe we'll be stretching it here. We'll say, what about when the target has been approached, right? So imagine two things. Three things actually. Imagine I file my GTR notification because I hit 3%. Then two, the target board calls me to say, hey, what's going on? Can we find out what's going on? So I send notification of shareholding, like you remember the case the Supreme Court case. So they get that. And then three, we have that discussion in Starbucks. And I say, well, we're thinking about it a bit. And I say, no, we're not interested, right? But then you go away. There's no rumor, no speculation, so I don't make a 2.2 announcement. Therefore, I don't make a 2.5 announcement, so there's no offer to it. Because there's no, 2.4. Now, in that case, even though there's no offer period, can we say that the sum total of those facts mean that there is a bid situation? Now, you struggle, but for purposes of Rule 21, there will be difficulty in you saying, hey, I can apply defensive measures. But I just feel people can make that argument, but I think you'll struggle.
Okay.
I
just wanted to know, I know it's changed you, and I would like to attend the course and take the assessment. And my question is, the assessment is the same it is indicated in the handout for me, right?
Well, you stage at the end of the year.
I stand till the end of this semester, yes.
Yeah, so you'll do the exams.
So I have to do the exams.
No, I'm asking that with you because there are some students who came for one semester, so they go back. And so we don't assess the exam. We assess the essay of 3,500 words.
I have to say until the April, May.
Okay. So in that case, we did the exams. Yeah.
I don't know.
Yeah, well, do you want to find out from the administrators?
Yeah, okay.
Yeah,
So I have to talk to them
yes,
about this.
yes, because the normal thing with exchange students, so if you say exchange, they're going to always think the exchange is, let's say, the Sander who have to write an essay. But you're saying yours is slightly different, so you need to clarify that so that they can decide which one, because I know that the right for you to write an exam with similar exchange students are writing at 3,000
Okay. Okay.
I just know